Troy, thank you so much for doing this. I heard a little bit about your career path, but for those unfamiliar, can you go ahead and lay it out in your own words?
Yeah, so when I tell other lawyers what I do, every lawyer without exception is on the plaintiff side says, man, I really want that for a practice. And so what I do now is my partner and I handle three cases, and that's it. Once we file three cases, we don't take another case until we settle one, and then we look for another one. We just settled one in January, so now we're looking for a third case to handle. We have two active cases right now. Now, that is separate and apart from some other of counsel trial work I do where I don't handle the day-to-day cases. But the Chandler McNulty firm was born in 2013, and my only regret is not having done it 10 years earlier. Because when you work for another firm, you don't have control over the kinds of cases you get to take, the kinds of clients you want to represent, that kind of thing. So now in 2013, my partner and I had worked at two other firms together, and I was kind of the managing lawyer of the dockets. And when I would move, I would insist that he come with me. And so we've worked at three firms together. As a plaintiff's lawyer, if you want to make a real difference and make a real living, you've got to have your name on the door. And so ultimately, Devin and I worked on a case that our future discussion, Chohan, will be right up our alley because it was a case involving only non-economic damages in which we got a $20 million verdict for. And then our boss didn't want to reward the effort, even though we had brought the case to the firm. We had worked it up solely by ourselves. We had tried it by ourselves. So that's how ultimately we started our plaintiff's firm. And by the way, most plaintiff's firms are started that way. We go work for other lawyers who can fund our cases and our careers for a while. And then ultimately, the plaintiff's lawyers are entrepreneurial in nature. And most of them I know of start because we always think we can build a better mousetrap and do a better job. So that's how we started Chandler McNulty. But I'll go back a long time ago. I went to your law school, University of Houston Law Center, and after which I went to work for the biggest plaintiffs firm in the country at the time. It was up in Dallas called Barron and Budd. And when I left, we had 80 lawyers. And for a plaintiffs firm, that's enormous. And it was 80 lawyers, none of whom billed a single hour. It was 100% contingency fee practice. So that was very rare in the country, and it still is. I don't know of a single plaintiffs firm that is still that big. Tort reform, corporate immunity laws, and Texas has shrunk that firm and every firm in Texas considerably since then. And since corporate immunity laws in Texas have passed, I've been licensed in 5 other states and mostly only live here. And I work around the country a lot more. We do keep one active case at all times in Texas, but like I said, our docket is very small and we absolutely love it because we know all of our clients by first name and know their kids and get cards on birthdays and anniversaries and things like that. And I couldn't recommend it highly enough just to keep folks, your practice small. I always tell lawyers, you will make more money turning more cases down and you'll have a better quality of life. So that's Chandler McNulty today. We're just two lawyers who work on three cases at a time. And if we can settle a case a year for 8 figures, which is what we've been doing since we've opened the firm after the first 2 years roughly, then we do very well. And our clients, we think, like that kind of level of service. So that's where we are.
Yeah. How did y'all make that decision to go from the high volume? Was it a conscious decision or did it naturally happen and you realized it was just serving y'all better, the smaller docket?
Yeah, all the firms I had been to prior to mine were very large volume firms. I mean, they were mass tort firms. I worked exclusively for the first 10 years of my practice in asbestos cases, which is still the largest mass tort in American history, probably anywhere in the world. And it's still going today. It's changed a lot, and they're not near the mass tort they used to be. So every one of my firms was mass tort. And I'll tell you, I remember very well a firm I was at after Barron and Budd, which planted the seed for me wanting to have my own firm where I had to control my own clients. And it was a case involving medical malpractice. I'd not been a medical malpractice lawyer. I tried a bunch of cases and had great training. So that wasn't an issue. I just needed to learn the science behind it and the alleged negligence. But it was a client who I didn't want to represent, didn't particularly have good feelings about, who had tried to commit suicide, and the emergency room doctor she was suing saved her life. And she was suing the doctor for an alleged mistake during his life-saving procedures. And I got to tell you, I had, as an associate, I had no control over who I represented or what kind of cases I did. I just took files and took my marching orders. But that was the seed that told me, man, it'd be really nice to have been able to not accept this case, but I wasn't a partner at the time and couldn't control that. So that seed was planted 5 years before I ever started my own law firm. And then the straw that broke the camel's back was the case I described to you, where a defense lawyer I'd done a lot of work against had referred us the case, and my boss didn't want to take it because it's a very tough case. It's an inadequate security case. Devin and I do three kinds of cases, and that's it. We do mesothelioma, which we both started our practices in. We do 18-wheeler truck crash cases involving catastrophic injuries or death, and we do inadequate security cases where we represent victims of crime. And it's really more crime victim representation because they're not all inadequate security. Some of them are other kinds of crime. But that was an inadequate security case involving an apartment complex that had a serial rapist running around the apartment complex. It was a tenant, and a great police officer here in Houston, an investigator who was the lead sex crimes investigator for HPD, had told the management of the apartment complex, based on what I've seen in these prior instances and this most recent one he was called out on, I can tell you, you have a serial rapist working your apartment complex. They're very much like predators in the wild. They have a territory that they work. And this apartment complex was in that guy's territory. And the manager did nothing about it and didn't send a warning to the tenants, anything like that. And as a result, our client, who was a single lady living by herself, was the next victim. And it was a horrible, horrible case. She was abducted in her own apartment, blindfolded, drugged, sexually assaulted, and told she was going to be killed for over 12 hours. The economic damages, how much money she lost, wasn't what the case is about. And this fits right into the Chohan case. It was all a non-economic damage model. Our economic damage model was about $1,200. It was emergency room bills that she went to right after the police came and rescued her. They did catch the guy because she was very smart. And right after he left her alive, she picked up the phone and called 911. And because that police investigator from Houston had told the local police working the area, if you get a call out of this apartment complex, it's going to be the same guy. Be on it right away and call me. And sure enough, I mean, this was really good work by the Houston Police Department. They got the call. The local police on the beat recognized the address and the kind of call it was, and they got there in time to catch the guy as he was leaving his own apartment and going to work. That case resulted in a $20 million verdict for that client, all of which, every single penny was non-economic damages. Because she wasn't claiming lost wages for a variety of reasons. Her performance prior to this wasn't stellar. So we didn't want to raise the issue of missing work and that kind of thing, because it would have made relevant some of her work related performances. Even though they weren't terrible, we just didn't want to go down that path. So we tried a purely non-economic damage case. What was the value of being held for 12 hours, as a hostage? And we can talk about that when we get to Chohan. But that case, that verdict, was a case that I had brought to the firm. My boss didn't want it. He made me write a memo as to why we thought we could get there on the law, because it's very tough in Texas. We're one of the toughest cases to get to a negligence finding on inadequate security. So I did that, and then we took it, and Devin and I did every single deposition in the case. We put on every single witness in the case, and we got a $20 million verdict, which was exactly what we asked for, by the way. It was every penny, and not a penny less or more than we had asked for in closing. And then that was February. That particular firm, our boss did year-end bonuses after the first quarter of the following year, not in December like most firms do. And he announced there will be no firm bonuses this year. And that just didn't sit right. And so Devin and I said, okay, never again are we going to suffer that indignity. We're going to go out on our own. And if we don't survive, well, that's on us. At least we only have ourselves to blame. So that was the straw that broke the camel's back. But the seed had been planted many years ago when I had to work mass torts and represent clients who I did not know until the Friday before the trial kind of thing. It was a kind of firm where Monday morning the trial lawyer showed up and the managing lawyer who had had the file would brief us, Friday, we work all weekend and then show up on Monday and try a case. And I didn't like
Mm.
that kind of a system. Now I live with my clients from the moment they're injured until the moment their appeal is done. And so I've had clients that have been with me for, 13 years ever since I opened the firm that we still talk all the time.
Wow. I can understand why that would be the straw that broke the camel's back. Yeah.
And
I'm also,
it wasn't about, let me make it clear, Thomas, it wasn't about the money. It was really what that means in the law and how we're respected for what we do. It was more to me, he didn't appreciate anything we had done. And that was what really stung. So the money that comes and goes, but it really was, I mean, it's an old cliche. It's about what it means and how to be respected. And unfortunately, in the legal business, one of the only ways we can do that is, well, how are you compensated then?
mhm. I'm curious just to add a little bit more color to this before we go to Gregory versus
Yeah.
Chohan. Do you remember your closing arguments from that trial where the
Oh
damages were
yeah.
so non-economic? Like, how did you anchor that $20 million ask?
Well, we'd gone in with a bunch of research first. We had focus grouped the case 3 times, and our focus groups told us the number to ask for, and they told us 10. And then by the third focus group, we asked for 10 and they gave 20. And that's exactly what happened at the trial. We asked for 10. I said they didn't give us penny less or more. That was wrong. I'm thinking of another case we will talk about, which is very similar. Um, but this one, we asked for 10, they gave us 20. The other one I was talking about was a $30 million verdict. And we did have one holdout, and it was a lady who just wanted to give more. But we can talk about the deliberations and what we learned after that. But the short answer to your question is, and how did I determine what we were going to ask for? What was the closing argument like? We did what the focus groups told us to do. We asked for 10, they gave us the 20 that the focus groups had done. So we weren't shocked about that. And then how did we get to that number? It was pre Chohan for sure, and it would not have survived appellate review, nor would that $30 million verdict I just mentioned have survived appellate review, because we settled that. And 2 months later, the Chohan decision comes down. And had we not settled it, it absolutely would have been taken away, because it was another case where it was 100% non-economic damages for the death of a father of 2 grown men who were doing well and not relying on dad for, raising them. They were 41 and 38 respectively when their father passed away. And the whole case was about the value of the father. And Federal Express, FedEx was the defendant. And you'll learn defendants have computer programs that tell them what they believe their case is worth. They literally put the facts into a computer, and it's not a human being telling them what they think the case is worth. So on their end, they had programs telling them at most this is a $2 million case. And so they got up to, during jury deliberations, agreed to pay 4.5. And by that time, it was just way too late and way too much time and money and invested. And our clients had sat through a 2 week trial, and that wasn't enough to even motivate anybody on our side. But again, we had focus grouped the case and listened to what jury research had told us. Now we're going to have to start focus grouping some things we'll talk about, per diem arguments and things like that in the focus group, to see how we can change or increase the non-economic damages award based on how we present it to the focus group. And it will be very different than we used to do, because in the FedEx case where we had $30 million for the death of a father, he was just a few years from retirement. He was 64. they never were willing to accept the fact that adult children could suffer that much because of the loss of their father. But here's one thing a computer program could not calculate, and it's all of our cases. This was a different relationship. These two young men were raised by their father as a single dad after their mother, when they were ages 8 and 11, respectively, left, just abandoned them and left the state and started another relationship. And then it was dad. And that's all it was. He was super dad. And we called a lot of family and unrelated neighbors and people like that to testify as to the strength of the relationship between these two young boys and their now super father, who, by all, I mean, I use that term because that's what we call them. And so there are some things in Justice Devine's concurrence. I read cheering in the Chohan case because it's true. These are things that can't have market value and aren't quantifiable. So we should be leaving it to the people who see the witnesses on the stand and can judge the credibility of that loss, rather than the cold transcripts that the appellate justices review. Um, so we can talk about Chohan more later. Did I answer the question? I probably got
Yeah.
off track.
Yeah, yeah, that works. And I'll go ahead and bring us into Gregory versus Chohan.
Yeah.
So I brushed up on this. This is something we read in our remedies class before you came and spoke to us a year ago. Went ahead and brushed up on it. We have a case where 18-wheeler jackknives, a bunch of cars pile up as a result, and some people pass away in the process. And one of the noteworthy things is I think one of the plaintiffs settles before trial, and a group of them go forward to trial. They try their case as a group, and they receive $38.8 million dollars. And what they had asked for was essentially in closing argument, they make this argument that you should give the trucking company your 2 cents for every mile they drove in the past year. That was 650 miles. And so when you add that up, it comes out to $39 million dollars. Well, they ended up rewarding 38.8. Not much of a mystery why there. Now, to the Chohan family, they got something like $16 million dollars,
Mhm.
more than 15 million of which was non-economic damages. What have I left out? What have I missed? And what is the takeaway of this case?
So I don't think you've got all the basic facts that we need to worry about. The takeaway, first of all, let me back up and say I live in that space. All of my cases are non-economic damages, and that's almost the only uh, loss we're talking about because all of my cases are either wrongful death or sexual assault cases. Remember, I told you I represent crime victims, and one of the areas we do a lot of work in and have for a long time is representation of sexual assault victims, whether it was we've represented Olympic gymnast clients or inadequate security folks who were abducted in their apartments, things like that. And these, by their very nature, are not cases where they have huge quantifiable economic losses. Now, if it's a wrongful death case involving a younger individual who could have lived for a long time and worked, sure, that's an easy quantifiable loss. But what I've always said, that's not the real loss. The real loss isn't how much did dad make and what could he bring to the estate. The real loss is what's it mean not having dad walk you down the aisle? And what would somebody trade for that if you went to the bride and told her, um, we're going to take away your father and he's not going to be at your wedding and not be able to walk you down the aisle. How much would you take for that? What would be a fair trade? Well, of course there wouldn't be a number, right? This is, as Justice Devine said, a non-quantifiable damage. So I live in this space. And the lawyers in Chohan and in the cases that followed that maybe were tried before the Chohan decision came out, but whose appellate history had to suffer the Chohan decision, tried cases the way I have for 25 or more years now. And so the reference to non-personal, objects like paintings or jets or the cents per mile, that was common. That's how we all did it. And those lawyers, I thought, did a very good job. And there's another case that some friends of ours here in town, the Arnold Litkin firm, who are fabulous lawyers, tried in Fort Bend County. And They had to suffer. They tried it before the Chohan decision came down, but its appellate history had to suffer the new Chohan rules. It was a $200+ million verdict, almost all non-economic damages for wrongful death in another trucking case. So, like Chohan, we deal with this a lot. So, I want to say, first of all, the way that they had been tried pre-Chohan with reference to inanimate objects and the value placed on them, and then comparing them to the value placed on real human beings and lives, this was very common. Now, it is taboo now. I mean, if you want to get your verdict overturned, do that and do the uh, appeal to a per diem argument like that that has no rational basis to the case. So we've done with what did we do before? Here's the big takeaway from Chohan. And it is anything but a clear paint by numbers guide how to do it. I can tell you the only thing we've learned from Chohan is what not to do, not what to do, because they tell us the non-economic damages must have a rational basis to the evidence presented. Okay, but what is the value of that lost father still? You know, so they've told us don't use unsubstantiated anchoring. That's an easy rule to follow. Okay, I get that. I know what I'm not supposed to do. Don't make appeals to punitive damage type arguments. Don't make appeals to passion or prejudice like size of the defendant. Like in Chohan, they reference size of the defendant, and in the industrial case I just told you about, Team Industrial Services versus Most. That's what it was. Uh, they were referencing the size of the defendant and arguing in closing arguments that could fairly be characterized as appeals to punitive damages. And there was an old saying among plaintiffs' lawyers, and that is bad facts drive damages. If you piss off the jury, they're going to award you more money. Well, Texas has clearly told us that is improper, and we can't do that. So, two very clear rules that are kind of helpful, but not for what to do, but what to stay away from. No unsubstantiated anchoring like appeals to painting, the cost of $1 million painting or a fighter jet. No appeals to passion or prejudice. Okay, that's easy. So, how do I now, in a post-Chohan world, in the FedEx case, how would I have argued for 30 million? Because we chose 30 million in that case because the focus groups told us that. We don't ever try a case without jury research on what the damages would be. And then we ask for that. That's how we have done it. We've said, well, what's the focus group told us they would award? And let's do that. Um, so how do I now make my argument to get what the focus groups told us they would pay now that I can't just say this is what I want you to award? Because literally in FedEx, that's what I did. I said, here's what I'm going to ask for at the end of the case. We believe the loss of this father is $30 million. But pre-Chohan, I did not provide a rational basis to the evidence of it in that case. They would have been perfectly justified under that ruling having taken it away. I asked for the most the focus groups had given in our jury research. So now here's what I think I'm going to do going forward, and I think talking to a lot of other lawyers will work. Let's take, for example, uh, the sexual assault case involving my client who was awarded $20 million. Here's what I think I will do. I will ask and I will elicit testimony, usually not from the plaintiff, because we very rarely ask the plaintiff to explain the harms and losses. We like to get objective, non-interested parties to do that because we want somebody without a stake in the outcome, right? We don't want somebody who's going to financially gain trying to prove our damages. And we don't like the plaintiff doing it because sometimes people see it as complaining, even though they're perfectly justified in trying to describe the impact on them. So we generally do it, number one, through somebody other than the plaintiff. But I will elicit testimony that gets this. What is it that you do that takes your mental anguish away, even if just for a little while? Well, Dad and I used to go fishing down in, wherever, Galveston, or we used to go to Port Aransas a lot, and there was a fishing cabin we stayed at. And boy, going down there sure brings back good memories and smiles to me. Okay, well, let's talk about how much it would cost you to do that. Now, that's not an economic damages argument because those aren't lost wages or medical bills, things like that, that I can recover for. But what Chohan is telling us is bring a number that is rationally based to the evidence that will make a difference in the life of this client. What will make it better? What will make her mental anguish better? So if I can say something like, what is it that gives you relief, even if temporarily? Put a value on whatever that activity is. It might be therapy. I have a great result when I talk to my therapist twice a week, whatever. Well, how much does that cost? Now, that is an economic damage, but we can also use it as an anchor for non-economic damages. Your therapy sessions cost $500 a session, not uncommon. Okay, so now we know it's going to take X number of therapy sessions. That's an economic damage model, but now we have an anchor to the case. We know, ladies and gentlemen, that the fishing trip down to Port Aransas is about a $1,200 venture per weekend. And that's what brings this client joy, relieves her mental anguish. Now, she is this old. She's going to live X number more years and days. And in order to relieve the mental anguish and the pain and suffering that comes along with the horrific things that happened to her or the loss of the loved one, she could do these kind of things. But she needs the resources to be able to do that. So we have placed a value now on what makes her mental anguish less severe, what gives her joy. And so what I think I'm going to do is take numbers like, give me an example of the fishing trip and how much it cost, um, or the therapy. And we will do a per diem argument that way on the non-economic damages. I have not seen a case yet that tells us that's a bad way to do it. Maybe we will because our Supreme Court and the courts of appeals are better at telling us what we've done wrong rather than telling us how to do it the right way. Chohan is a perfect example of that. Um, and so that's what my next case will be. It will be what brings you joy? Give her that amount every day for the rest of her life or every week for the rest of her life. However, we can make that number fit with what our jury research told us. For example, if the focus groups tell us $30 million is a number that they would give, now I will back my per diem argument into an amount where I get that number. Is it per day that gets us that number? Is it per week? Is it per month? Is it per year? And that's how we will produce it. That's my plan going forward. And I haven't seen anything yet that says I can't do that.
That's awesome. Thank you so much. Very practical, and that's definitely helpful for me going forward. I'm curious to know in your career, what has been the most rewarding case you've tried?
Oh, this is there's a bunch, and one of them is that abduction case I told you about because my client uh, is still a dear friend, and she moved out of the state, but every time she comes back to Houston, which is once a year, we always get together and have dinner. Her and her husband, they are wonderful, wonderful people. So that's one. But I would go back all the way to my very first job for that. I worked at an amazing firm out of law school that really, really took the mentorship and training of young lawyers seriously. Lisa Blue, who was one of the country's finest trial lawyers, in my opinion, and certainly one of the top three jury consultants in the country. She was a PhD psychologist before going to law school, and she was one of my mentors in my first job. And we had a docket that I got assigned to as a baby lawyer. In my first year, and I got what was called the Tyler Pipe docket. It's called the Tyler Pipe docket because Tyler Pipe made cast iron pipe in Tyler, Texas, and we represented men who got latent diseases from asbestos, either asbestosis, which is a scarring of the lungs caused by the inhalation of years of exposure to airborne asbestos, or cancers that take much less asbestos to do, but it's caused by unregulated and uncontrolled exposures. And so we represented a lot of men. And what we had found in our client population, we represented 130 men out of that plant, 95% of whom were African American. Well, why is that? Then we started getting into the documents, and they produced to us um, 3,000 banker's boxes. A banker's box carries about 3,000 pages, so it's about 9 million pages of documents that we spent weeks and months going through. We culled them down and culled them down and culled them down into, by the time we went to trial, about 8 binders of what were really, really good documents from about 9 million. And in there, we found the secret as to why 95% of our clients were African American. And that is because throughout the history of this plant, African American men were put into the jobs that exposed them to the most hazardous environments. And they literally had job requests for, quote, Negro or colored men, unquote, to do certain jobs, signed off by the president of the company. In 1964, these are latent diseases. So we're talking about men who worked there in the 50s, 60s, 70s, and into the early 80s. And their diseases developed in the 90s and 2000s and 2010s. So we're trying these cases in 2000s, 20, 30 years after these guys no longer work there. They're now in their sixth, seventh, eighth decades of life suffering with these diseases. And we had to explain to the jury why it's just, we tried 8 guys all at once. Why are they all African American men? And when they learned it was an official policy of the company to place, quote, colored or Negro men in these jobs, they understood why our clients who they were. So we actually made a big difference, I think, in that case with the way because with the way employment in Tyler at the time was. Now this was 2000, but here's what we knew about Tyler plant, or pardon me, Tyler Pipe, because it was still operating. Our clients told us, Troy, they don't make those requests anymore in writing, but the practice still exists. We are still very much in the 20th, late 20th and early 21st century. Here we are now, and I think it was 99 or 2000 when we were trying the case. They're still doing it. But after we hit them for 2 consecutive verdicts back to back, we tried one. They didn't want to settle for all of our clients, so we tried another one and hit them back to back. They resolved their cases and started changing their work practices. I mean, it was hard to believe that as late as 99 and 2000, those kinds of practices were still happening, but they were. And so that was a hugely rewarding case. Now, I was a 1-year lawyer, 2 years by the time we had tried those cases, and I had spent on behalf of that firm $1 million in hard expense money, hiring experts and traveling around the country and doing depositions and document productions, things like that. And nobody asked me ever, what the hell are you doing? You spent $1 million? And that's the kind of firm it was. I mean, there is not a firm I know of where a 1-year lawyer could start racking up those kinds of bills without a single partner coming to them and saying, what are you doing? Now, thank goodness we had got 2 successful trials back to back and then settled the entire docket and made a huge difference in the lives of our clients. Otherwise, maybe somebody would have asked me questions later. But I will never forget that group of plaintiffs because it was the first trial I had done. Lisa Blue and I did it together back to back. So that was incredibly rewarding. But then the last one, we just resolved. This wasn't a trial, but we resolved it. And we're going to do a lot more of these cases because they're huge. And the way you want to make a difference is handle a few cases in a specialty and change the way these companies do business. So now what we have done in all our settlements, where we have the leverage, is we don't just insist on monetary settlements. We insist on changes to policy or practice. So in the Robinson case, can I show you something? I want to show you.
Yeah, absolutely.
Let me shrink my screen here. I want to show you one of my favorite clients, Dale Robinson. If I can figure out how to share my screen, nope, I got to open it first. Sharing is not turned on. Oh, okay. Can you turn on sharing? Because I want to show
Yes.
you a video.
There we go. Just hit allow.
There we go. Okay. I want to show you. Can you, now I'll share my screen. Okay. Can you see that PowerPoint?
I can, yes.
Okay. So,
I think if you put it in
yeah.
presentation, it'll
So
be, yeah, there you go.
this is on, as I'm looking at the screen, my left, the Santa Claus, that's Dale Robinson. On his lap is Brinley, his granddaughter. In the middle is Dale's son, Casey, with his daughter, Brinley. And on the right is what happened. And let me show you the way we would try to work up, or we would try to prove economic damages prior to Chohan. Now, this is definitely an appeal to emotion for sure, because case law tells us you can't decide a, you can't render your verdict based on sympathy, but you can use empathy, which means something very different than sympathy. Sympathy is I feel sorry for you. Empathy is I understand and I feel what happened to you. I hear you and I understand versus I just feel sorry for you. And so this is Dale talking about the loss of his son.
I haven't found the I, I haven't found the end of crying at all. And it just comes when it comes. You're just angry or sad because you're never going to continue that relationship. It stops there. You don't forget, it just stops. It quits moving forward. I know my wife feels the same way, but it's that every day. Good morning, Dad. Good night. Good morning, Grandpa. And it is just gone forever.
Now, if you ask Dale Robinson, how much would you take for the loss of your son? Do you think he'd even give you a number? Of course not. So, how do I value that loss? First of all, you have to understand it. And the only way you understand it is to know and live your client's experience as much as you can. You'll never experience what they're going through, but you have to spend the time with the family. Dale, Dale's son, they lived out in the country up in North Texas, on a big piece of property where the whole family lived there, where Casey and Brinley and Casey's wife lived in a house literally 100 feet from his dad, and Casey's brother lived in another house another 100 feet away. And this was a very, very close family. So you asked about cases that meant a lot. This one meant a lot, not because we got a huge verdict. We got a very, good's a relative term considering what happened. I'll never say it was good because it didn't replace what this wonderful family lost, but it was a lot more than even in the insurance they carried. We did some creative lawyering and they had a miserably bad insurance policy, but we got multiples of that and got the defendant to pay out of pocket a lot. But the better thing we did, and here's why I was so proud of that case, is we made them change practices. This was a garbage truck company where the driver of the garbage truck fell asleep at the wheel. Sitting next to the driver was the assistant in the garbage truck who would run out and make sure the garbage got into the back of the truck, right? He would run out and pick up the cans and put it in there. Well, this guy, a young 20, 21-year-old kid, is like this the whole time on his phone, just doing that as the driver is barreling down a rural highway, approaching a stopped school bus with 5 cars parked behind it as they unloaded children at the end of the day. And we have a dash cam and we see the driver doing this. And for 20 seconds, he is literally asleep for 20 seconds at the wheel, going perfectly straight. He's not weaving anything. That big truck kept a straight line while he was at the wheel with his head down, literally asleep. And while his passenger is clueless about the whole thing because he's just doing this on his phone. So one of the things we did in that case, and we've done in others, is we made them make changes to their policy and procedure manual. So in that particular company now, not only is it a violation of DOT regs and company policy for the driver to be on the phone, but no one in the cab now can be on the phone because we made them put it in their policy and procedure manual. Nobody can be on the phone if they're in the cab of that truck, because if they had another person in that truck who saw that the driver had fallen asleep, this wouldn't have happened. The other thing we did is we make them watch that video you just saw of Dale and the other family members. All new hires have to watch what we call our damages video. We put this together for mediation, and all new drivers have to watch it so they understand the impact of their decisions when they get on the road. And so when you can do that, that's amazing. And we do it in every single case that we settle. Um, Now, the degree to which is dependent on the leverage you have in the case, right? Sometimes you can make sweeping changes. Sometimes you can just make them do a few tweaks that will make a big difference, but aren't overhauling their entire procedures. So uh, that was a great one. I'll make one last case that I thought we did a lot of great work on and will continue. Fast food in this country employs more children than any industry in America. McDonald's employs more children than any single employer in America. McDonald's has a corporate policy that says we will not hire registered sex offenders. That's great. Good. But here's the problem. 95% of McDonald's restaurants are franchise. And McDonald's corporate stores do not enforce the policy they have for their corporate stores, which is only 5%, to the rest of the franchisees. Franchisees are allowed to hire whoever they want, convicted sex offender or not. So, and this is most of the fast food industry. So in cases like that, we can do a lot of good by making sure that the franchisees that we settle with change their policies. We just recently settled a case with a fast food restaurant where they had hired a twice convicted registered sex offender to work with 15-year-old girls. And of course, the inevitable happens. And our client was sexually assaulted on the job. And it was a terrible thing. And she gets, and like 90+% of all sexual assault victims, she was not going to make a complaint. She was going to go home, quit her job, never go back, and never say a thing. And by the way, that's most of our clients. But her friends, to whom she did confide, looked up the defendant who had done this to her coworker. He was a 28-year-old man who had two prior convictions for sexual assault of children. And because she learned that, she said, well, this can't happen again. I will go to the police. And so she did make an outcry at school, and the police did get involved. And because she did that, now on his third conviction, he was sentenced to 40 years in prison. And because it's his third conviction, he will serve very close to all of it. So that case made a big difference because we were allowed to change policies in the settlement so that future employees of that particular franchise owner will not be working with registered sex offenders. So when you have the leverage to make policy changes, you can make a big difference. And that is more rewarding than any of the financial benefits that come with this, which which can be great. It's a good part of the job. But the better part of the job is seeing that young girl, she's now 18, with enough financial resources so that if she wants to do therapy every day for the rest of her life, she can do it. And if she wants to move out in the country and not be around anybody and buy a plot of land so that she feels safe, she can do it. So
That's amazing. Your career is really inspiring, and I'm thankful that you've been able to talk to me about it. I'm curious, we live in a time where for trial lawyers, it's not the same as it used to be, and hearing about your first job coming out of law school kind of highlights that. It's not like that for a lot of lawyers starting out. And so, what is some advice you would give to a young trial lawyer just embarking on their career?
Okay, so great question, and you're right. Unfortunately, there are not a lot of firms who will invest the time and money in you because you more likely than not, you're not going to stay at that firm for a long time. Well, after your second or third year as a lawyer, you will get a lot of phone calls from legal recruiters trying to chase you, trying to take you away and put you in another firm. And as a second or third year lawyer, now you're the most valuable commodity for any law firm because now they can start making money off of you. And there aren't a lot of firms that will take you under their wing and give you the mentorship and the guidance and the training in your first job because they just know you're going to be gone in a few years, or they don't want to create their competition. So if you can find it, find a firm who values giving you more tools for your toolbox. Every job you have, think of it as somewhere you're going to pick up a tool and you're going to put a new tool in that toolbox because eventually you're going to start your own firm or do your own thing. And you want every place you go to be somewhere where you can pick up tools. So if that's a firm that will do that, great. So look for those opportunities and really inquire of their former associates. Don't believe them, believe the people who used to work there. Are they a firm who gives us tools so that we can build a bigger toolbox? Secondly, I will tell you less is more. We make money turning cases down. We make a difference turning cases down. We help our clients more when we have fewer of them. So it's the old Jerry Maguire movie. Remember that where he was arguing less clients? Well, that's it. As a lawyer, I promise you will be more satisfied with fewer clients. Yeah, it's more risk because if you're going to take fewer cases, you have to make sure those cases pay off, right? But when you have the time and resources to put into that case, they will. Unlike a lawyer who has 100 files and he doesn't even know the witnesses' names on the file. So training, go where you can get the best tools. Two, less is more. Yeah, that's it. Less is more. It's my biggest advice. Oh, I'll give you one last one because it helps me even to this very day. Be nice to everybody in law school. Everybody. My biggest referral source to this day are the lawyers I went to law school with because they know that I'm one of the few in our class who do plaintiff's personal injury work. And because I wasn't an asshole in law school, I get a lot of calls from folks I went to law school with. So toolbox, less is more. Be nice to everybody because everybody is a potential referral source, even and especially maybe defense lawyers. Be nice to them, be professional to them, make them want to work with you in the future by sending you business. In addition to my classmates, the second biggest source of referrals is lawyers with whom I have worked against. They call me when they have cases. So,
Wow. That's awesome. And it shows, I think it's a newer breed of lawyer that advocates for this scorched earth approach to the practice of law, make the other side's life as hard as possible in the hopes that it will make them want to settle with you more. And I don't know, I have a hard time subscribing to that. And I find I love hearing from lawyers who are successful say that is not the way to do it.
and
And yeah.
yeah, and I'll tell you when you face, and boy, there's a lot of those guys, a lot of them, and this job is so stressful. And we don't need to make it more stressful. When I take on a new case and a defense lawyer answers a case, the first thing I do is I send them a blank Rule 11, a letter that says this Rule 11, fill in the blank, is good for any discovery issue you need to get out from under whenever you need it. Just fill it out and send it back. You got a freebie for anything you need to get out from under because you screwed up and missed a deadline or whatever. Do that at the outset. It'll set the tone for the case. I promise you, it'll be a more rewarding uh, experience because you're going to live with that lawyer for 2 years.
Mhm.
So
Yeah.
make it as pleasant as you can. And that asshole who is the scorched earth guy, he can't out scorch earth you if you only have 3 cases you're working on. You have all the time in the world to deal with all his bullshit. He
Yeah.
doesn't. He doesn't. Now he's moving on to his second, third, fourth case of the day, not of his docket, but the second or
Mhm.
third or fourth lawyer he's trying to be an asshole to for that day. And when you have more time to respond to his bullshit and file your own motions to compel, that kind of thing, they can't scorch earth you.
That's awesome. Troy, thank you so much for your time. I'm going to end the recording there, and then if you stick around, we'll say proper goodbyes
Hey,
afterwards.
you're working with a good firm in what in the field they do. They do first party insurance stuff. I know, and they do it very well, and they're great lawyers. So good luck to you. Make them give you the tools for your toolbox, because I know John Scott Black and Rick Daly very well, and they do very well, so they can afford to do it for you. So make them give you
Sounds
good tools.
sounds good.
All right, thank you.